This week, we'll be talking about the False Claim Act. Here are some of our objectives. The False Claim Act is one of the most powerful tools that the government has for fighting fraud and abuse. It was enacted during the Civil War, and during the Civil War, the federal government used a lot of private contractors. And those private contractors took advantage of the situation. For example, selling inferior goods such as sand instead of sugar, sawdust for gunpowder, and boots made of cardboard. President Lincoln then declared that to be a false claim against the government, and that is why it is sometimes referred to as Lincoln's Law. And it was further expanded by the Fraud Enforcement and Recovery Act of 2009, as well as the Patient Protection and Affordable Care Act of 2010, also known as PPACA. The False Claim Act prohibits the knowing submission of false claims for payment, knowingly the use of false claims or statements to support those claims, knowing and improper retention of money belonging to the federal government, as well as conspiring with others to commit any of those acts. A false claim may be seeking reimbursement for services not medically necessary. It could also be for services not actually performed, filing a claim for services or treatment delivered to a patient who does not exist, filing a claim for services not covered by Medicare or Medicaid, or for services to a patient who is not a qualified Medicare beneficiary. This prohibition can occur only when a false claim has been submitted. False claims are almost always supported by some form of documentation. Medical record may be altered. It's more true of that when we had paper records. False certification of a patient's qualification for Medicare may be created. The basis for the False Claim Act liability is often referred to as a reverse claim. So rather than filing a false claim, the person or the organization hides or avoids paying back the money that is owed to the government. And the government actually says that you only have 60 days to repay that overpayment. And the clock begins ticking on the day of discovery. Any person who knowingly conspires to commit a violation of the False Claim Act under the section of the False Claim Act, there must be at least one other person involved. The conspirators must agree with each other to do something that would be a violation. The False Claim Act covers healthcare providers such as physician practices, hospitals, managed care systems, laboratories, pharmaceuticals, drug companies, ambulance services, etc. Technical violations do not create a false claim. Mistakes do happen, and mistakes are not considered a false claim. The term knowingly attempts to define the necessary state of mind of the person submitting the claim. The person must have actual knowledge that the claim is false. The person must act in deliberate ignorance or reckless disregard, and it is not necessary to prove specific intent to defraud. A private citizen may bring a False Claim Act lawsuit on behalf of the government. That person is frequently an employee or an ex-employee. That person is called a whistleblower or is called a relator. Qui tam is Latin for who as well. The government then may take over the prosecution of the case, and the whistleblower may receive anywhere from 15 to 25% of damages that are awarded in the case, as well as attorney's fees. The consequences for violating the False Claim Act are several and serious. The damages are the difference between what the government paid and what would have paid without the violation. The person or organization could be temporarily or permanently excluded from participating in government programs such as Medicare or Medicaid. There could also be triple damages. So take an example of 1,000 improper upcoding claims with an average gain of $50. So 1,000 times 50 times triple damages is 150,000. But the court may assess a penalty of a minimum of $5,500 to $11,000 for each claim. That now brings the total in penalties up to $5,500,000. The False Claim Act is a civil statute, but other federal laws allow criminal prosecution of the same offenses, such as false statements or representations, false statements relating to qualifications for participation, criminal health care fraud, as well as obstruction of a criminal investigation. And so the False Claim Act is a civil statute with a lower standard of proof. There are federal criminal laws that cover many of the same activities, but require a higher standard of proof. Some risk areas for providers include filing a claim for services not delivered, filing a claim for services or treatments for patients who did not exist, violation of the anti-kickback law, and that is receiving money or property in exchange for referrals to patients. Seeking reimbursement for services not necessary is also a violation. And under the federal Stark Law, physicians are prohibited from referring patients to or ordering goods or services from entities in which they have a financial investment. Other risk areas include falsification of hospital cost reports, redlining. Redlining is when hospitals and insurance companies increase their profits by enrolling the most healthy of patients. Off-label marketing, illegal kickbacks, inflating drug prices, and Medicaid best price fraud, as well as pharmaceutical benefits manager fraud. The majority of cases originate with qui tam realtors and the law firms that represent them. In fact, in 2007, $2 billion was recovered in false claims, and over $1.5 billion of that came from healthcare fraud. So listed here are ways to minimize the exposure to the False Claim Act. I encourage you to review the compliance plan for hospitals provided under the web link on the left-hand side of Blackboard. Even with an effective compliance program, one cannot eliminate fraud. Thank you, and please do not hesitate to call me if you have any questions, or you can email me as well.